Let's get started here. This is the presentation by the Master of Science in Patent Law program at the University of Minnesota Law School here. My name is Chris Frank, and I'm going to be presenting to you the background of Science and Patent Law program and some careers that exist in patent law that don't require a law degree. So thank you for coming. Just to introduce myself, my name is Chris Frank. I'm the director of this program. And what I want to do is introduce you here to how I got involved in the field of patent law. My career started out actually as an engineer in the medical products industry. And one of the first things I did, I worked at a Fortune 500 company. And my job was to do product testing, comparing our product to that of some competitors. And the results of my testing were that the competitors had significantly superior products to us. And so I thought this was my chance as an engineer to come up with the next great thing. But before I proceeded to invent the next great thing, I talked to my boss about my ideas, and he said, "Oh, hold on a second there. We don't need any new ideas. What's going on is the competitors are engaged in a patent dispute, and what we're going to do is buy a winner." So that was kind of my first experience with patent law. And I thought that wasn't what I went to engineering school for, so I quit and I went to a startup company. And at this startup company, I had another experience in patent law. It was a medical product again. We went through FDA approval, our company went public, and essentially the first day that we started selling products, we were sued for patent infringement. This second experience was enough for me to realize that there's more to the world than engineering, and that if you don't understand this world of patents, you're really missing a big part of the picture. So I went to law school and practiced patent law for a few years, and then I went in-house at a large medical company in town here as a patent portfolio manager, where I reviewed hundreds of ideas each year to decide which ones we should patent and which ones we should not. And then after doing that for about 5 years, I just started here at the University of Minnesota Law School as the program director of this program that's now in its first year. So that is how I got into the world of patent law, and now I want to introduce you to this world, starting with this kind of simple diagram of the Master of Science in Patent Law program, which also is based upon the types of roles and careers that are available in this field. Starting kind of with that bottom row, it all begins with innovation, that idea that someone comes up with in the research and development phase. That is a part of the patent process. It can be spurred by ideas that are already out there or already patented even. Or it can even be spurred by designing around an existing patent, which is often the case. Once the innovation is completed, we go into what's called patent prosecution. And patent prosecution, it's not a good, very informative name, but that is what people who draft patent applications call themselves, patent prosecutors. They write patents for you. So that is another role that someone interested in this field can be, is to draft the patents for the inventors. Once that patent is drafted, you then go into the process of value extraction, making money from your invention that is now protected with a patent. And there are a number of ways to do that. Most commonly, you will sell a product, or you will license your technology to another company who's selling the product. Or thirdly, you can sue someone for patent infringement, for infringing on your patent. Now, that's the simplified view of the world. Come up with an idea, patent it, and make money from it. Now, to make matters more complicated, most products are not the result of simply one idea, but many. For example, the original light bulb invented by Thomas Edison had over 400 patents involved, not just one. The original iPhone had over 2,000 patents and counting. Each iPhone has thousands more patents as that technology progresses. So then we see that top row, you see the kind of catch-all portfolio management. As companies have more and more products and more patents, they need what are called portfolio managers to decide which of our ideas we should patent, which ones not, which ones are going into the product, which ones are not, which ones can we license out, which ones can we litigate on. So these are kind of the four basic broad buckets or categories of career options that are available in patent law, and also kind of form the basis of our Master of Science in Patent Law program. So what type of opportunities exist in patent law? What I have here is what I call the opportunity gap. So you can see this top line, this light blue line going upward fast, is the number of new U.S. patent applications filed each year. And the number has nearly doubled from the year 2000 to the year 2013. In that same period of time, this flat line on the bottom is the number of new patent bar members entering this field. And it's clearly not kept pace with the increase in patent filings. Now, this graph represents two different types of opportunities. Number one is just the straightforward opportunities and people that will draft patent applications. But number two, as companies become more sophisticated in the field of patent law and intellectual property, we need people that can offer a more sophisticated analysis of the patents that are out there. So as we discussed, the patent portfolio managers, the licensing technology specialists, and that sort of a thing. So the first question that we usually get when we talk about patent law is, don't I have to be a patent attorney to work in this world? And the answer is no. There's actually a number of opportunities out there that do not require the 3-year degree that is required in order to become a patent attorney. There's something called a patent agent. What a patent agent is someone with a science or engineering degree, and they have passed what's called the patent bar exam. It's a 1-day, 100-question exam offered by the United States Patent and Trademark Office. Any scientist or engineer with the proper technical background is eligible to take this exam and become a patent practitioner that can do certain things in the area of patent law that we will be discussing. Compare that to what's required to become a patent attorney. A patent attorney has to have the science and engineering degree plus the 3-year law degree, plus they have to pass the state bar exam to become a lawyer and the patent bar exam to become a patent attorney. So how come I've never heard of a patent agent before? Traditionally, the patent agent role is something that has been pursued kind of mid-career by an engineer who may have 10, 15, 20 years of experience and a number of patents to his or her name. At that point, they will discover that there is this role called patent agent that's always been available, but they just weren't aware of. And so a lot of the positions for patent agents have often even been filled by internal people such as the engineer with 20 years of experience. And so there aren't even that many job postings that have traditionally been out there because it's kind of this separate field that not many people are aware of existing. But as we've seen with the number of patent applications rising so fast, it's become an actual career choice that people can make as an undergraduate. So what is the difference in the roles that a patent attorney will do versus what a patent agent will do, just so that you can kind of decide for yourself if possibly you're considering going to law school, but you're questioning whether that 3-year investment is worth your time. A patent attorney and a patent agent can both draft patent applications for other people. Someone invents something, you can draft a patent for that person. As a patent agent, you can literally hang up your own shingle, run your own business, and have clients that are inventors and write patents for them. You don't have to go to law school to do that. Now, these next few things listed under patent attorney are things that you do have to be a lawyer in order to do. A patent attorney can draft legal agreements and legal opinions, and they can engage in litigation. A patent agent can't do those things. However, a patent agent will often have roles that are very different than a patent attorney. They are more business-related roles, such as patent research. And patent research often relates more to the question of, is this idea patentable or not? You can become a patent researcher and answer these kinds of questions. Additionally, you can become a portfolio manager. Now, as a portfolio manager, this was a business role, not a legal role. So a lot of what I did, I had to work with the patent legal group in our organization while I represented the business group of portfolio management. And within my group of portfolio managers, 2 of us were patent attorneys and 2 of us were patent agents. So clearly we were all doing the same job. Patent agents did it just as well as the patent attorney, and we hired patent agents just as much as we hired patent attorneys. Last but not least is innovation. Where I worked, it was a very innovative Fortune 50 medical products company. those engineers and scientists who understood patents and patent law and what it takes to get a patent were much better innovators because they're to more clearly articulate what it was about their invention that was original and unique and patentable, and also why it was important and valuable from a business perspective. So understanding patent law also will make you a better innovator. So I'll go into a little bit more detail about each of these roles as we go on, but what I want to first do is give you a background in patent law in general, because most people have heard of patents, but they don't really have much of an understanding of what it really takes to get one, what the requirements are, and that sort of thing. But first, I just want to kind of show you that there are legitimately a very large number actually, of positions out there looking for not patent lawyers, but non-lawyers that understand patent law. The example I give here is Apple a few months back had a patent technology analyst posting, and it specifically said that patent lawyers can apply if they want to. Patent lawyers who prefer to focus on the technological aspects of patents can be considered, but you can see in the last line, this is a non-lawyer position. So you have a position here, they're not looking for a lawyer. They assume that lawyers might apply, but the fact of the matter is they don't need a lawyer to do this role or this position, and there are numerous positions like this out there. Here's just kind of a random sampling, and you can see it crosses a wide range of technologies and industries, from vaccines to Coca-Cola, food products, IBM, Avery Dennison, the label maker. Yes, they're involved in patents also. Pharmaceutical companies, Microsoft, etc. Also, there are law firms now that are willing to hire, or looking to hire actually, patent agents or patent attorneys for the same position, because once again, a patent agent can do the same job of drafting patent applications as a patent attorney. So hopefully this clears it up for you that there is a legitimate opportunity out there for scientists and engineers interested in working in the field of patent law, and it doesn't require that you have a law degree. Okay. Salaries, that's the second part you might be interested in. How much would I get paid if I pursued this career? Now, because it's typically been something that people do move into mid-career, there's not a ton of information out there, but from what I've found, the $80 to $90 range is kind of a good starting point to think about. It's going to, of course, depend upon your technical background and whether you're at a law firm versus a corporation and that sort of a thing. But the fact of the matter is, the numbers out there seem to bear out, and also from industry potential hirers that are out there, kind of the $80,000 mark is kind of where patent agent salaries seem to begin. Okay, so once again, this is our opportunity gap. The gap is real. There are all kinds of opportunities out there for new patent practitioners that don't require a law degree, that are quite interesting, and we're looking for scientists and engineers that would like to pursue those opportunities. Okay, so let's go into some patent law basics. Just so if you're interested in learning about this field, you got to know some of the basics of patent law, and then we'll kind of talk about a day in the life, that sort of a thing, of what it is. So where do patents come from? We have our United States Constitution, that in order to promote the progress of science and the useful arts, we want to secure for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. So patents are intended to be a public benefit. In exchange for you, in a patent application, teaching the world how to make and use your invention, we will give you a limited monopoly on that idea. So the thought process is, if we give you a limited monopoly, you will tell us how you may use your invention so that others can look at it and improve upon it from there. So it's supposed to promote innovation. Now, of course, there are questions as to whether that's actually what's happening by the way that our patent system operates. Nonetheless, that public policy is the intention behind it. Okay. So patent law basics. Patent law falls under an area of law called intellectual property law. It includes copyrights, which are generally applied to works of creative expression, movies and novels and books that you may write. Trademarks, on the other hand, refer to business names and slogans, the Nike swoosh and that sort of a thing. And then patents kind of are in the middle. They refer to more technological inventions and that sort of a thing. The media will often get this wrong. They'll refer to someone's catchphrase as being patented or a song as being patented. It's simply incorrect to refer to them that way. And we just have to accept that sometimes people misuse these terms. But when we're talking about patents, we're talking about technological innovations or inventions. Okay, so what does it take to get a patent? There are essentially three requirements. It has to be useful, new, and non-obvious. And I'm going to show you kind of a quick way to think about these three requirements in order to get a patent. First of all, usefulness or utility. How useful does an idea have to be or an invention have to be in order to be afforded patent protection? I'm going to show you a couple of actual patents here to, first of all, judge for yourself. This one here, issued in 1995, is a method of exercising a cat. So the invention is to take a laser pointer, point it around the room, and have your cat chase it in order to get exercise. That was useful enough to be a patent. This next one is a cringeworthy patent, if you've ever seen one. It's an apparatus for facilitating the birth of a child by centrifugal force. I'll allow you to take a couple seconds to look at the invention and figure out exactly what's going on there, and ask yourself if that really looks like a useful invention. The very obvious answer is no, it's not. And just to erase that from your memory, here's one more questionably useful invention. It's a patent for a fantasy football system. So how useful is it? How important is it to the world that we protect an idea for a fantasy football system? It kind of tells us that the requirement for usefulness is not a giant hurdle to get over. An idea just needs to be minimally useful for its intended purpose. So for example, there's an entire category of patentable inventions for board games. So board games are useful enough for passing the time, that sort of a thing, so that they qualify for patent protection. So this first hurdle is very low. Any kind of new idea is useful enough to be considered for patent protection. Second question then is novelty or newness. How new does your idea have to be? How different does it have to be from what's already out there in order to be afforded patent protection? Well, let's look at the high technology of the coffee cup sleeve. So back in 1993, this was the state of the art. We had a corrugated cardboard coffee cup sleeve with basically a series of long ridges going around it. Well, the technology advanced from there to the year 2000, and you'll see here there's even some sort of a heat transfer diagram on the right-hand side, and someone must have looked at coffee cup sleeves and said, I think that the ultimate way to prevent the heat transfer is to use dimples instead of ridges, and that was apparently different enough in the year 2000 to be afforded patent protection. Okay, and let's go further, closer to the present. In the year 2013, someone came up with the next great idea for a coffee cup sleeve. And this time they said, you know, it doesn't really matter. These sleeves, your thumbprints are going to be burned off no matter what. So instead, what I'm going to do is put a little tab there and use gravity to rest the coffee cup on your thumb so you don't have to hold it so tightly and burn your thumb. So that's 2013. And that was new enough, novelty-wise, to be afforded patent protection. So the question of how new does something have to be in order to be on patent protection just has to have some sliver of newness, something different that's not already out there in order to get patent protection. So that's our second hurdle. Also not a huge hurdle, but we come to our third one, and this is where the money is made in the world of patent law, is whether or not an idea is obvious. So even though it might be useful and it might be slightly different or slightly new, how obvious is it to make those changes? Can I just change the color or change a single dimension and get away with getting patent protection? What does it exactly take? So in the field of patent law, the answer to this question depends on who you ask. And the question that we ask is, would it have been obvious to a person of ordinary skill in the art? And so we're talking about science and technology, but we use the term art in patent law. A person of skill in the art, for example, of coffee cup sleeves at the time that the invention was made. So imagine a person of ordinary skill in the art of coffee cup sleeves. They are not heat transfer experts, and so they are afforded some degree of latitude in coming up with some ideas that might be more obvious to a person who is an expert in heat transfer. So what you're doing is you're making this argument with the patent office about whether or not this fictional person of ordinary skill in the art would or would not have thought of your invention. Now, just to make this more clear, let me use some real world patents again here. I'm going to use this example of rolling luggage. So in 1972, someone patented the idea of putting wheels on the bottom of your luggage and then added a flexible handle at the top. So instead of carrying this 50-pound bag, you could just roll it right along. Good idea. Well, there was a couple of problems with this invention. The wheels were very small and the handle was flexible. So if you tried to turn a corner, it would usually fall over. Or if you tried to go too fast, it would fall over. In other words, this invention was actually a complete failure. Good idea, bad product. And it wasn't until almost 20 years later, in 1989, the patent was filed, 1991 it was issued, that someone actually improved and perfected this invention, adding a wider wheelbase and larger wheels and a rigid handle. So when you turn the corner, the suitcase doesn't fall over, and when you go fast, it doesn't fall over, solving all of these problems. So now, when we talk about whether or not something is obvious, let's just look at the timeline for these inventions and think about it. It's not rocket science. Rocket science is easy. We went to the moon in 1969. We invented the original suitcase on wheels a year later in 1970. We didn't perfect the wheel for another 20 years, 1989. That was after 4 billion people traveled on airplanes and probably tripped over their bags and that sort of a thing. So even though in hindsight, the rolling luggage idea seems obvious to us all, it clearly was not obvious. And so the patent office is often criticized for allowing these obvious or simple inventions, when the fact of the matter is, in the real world, it's pretty hard to get something right. 20 years to master the wheel on luggage. So that's the patent law basics. It requires 3 things: usefulness, newness, and not obviousness. Now, if it's not absolutely clear to you, that's fine. It is the job of the patent professional to make the argument about whether or not something is obvious. And so it's not something, it's the way we refer to it as something upon which reasonable minds may disagree. One person may think it obvious, another may think it non-obvious. It comes down to your ability to make the argument one way or another as to whether something will or will not get patent protection. So that's the basics of patent law. Now I'm going to kind of walk you through the patent process. What does it take to get the patent allowed? Is it fill out a form and pay a $20 fee, or is it more involved? Is it a year process, 2-year process? What's involved here? What I'm going to use is an invention of the cheese crust pizza patent. So can you really patent a pizza? Once again, we ask the question, is it useful? Well, it's food. It helps us stay alive. So yes, it's useful enough. Is this cheese crust pizza new? Well, we're going to look at a patent search. At the time it was invented, it appeared to have been new. And then the third question is whether or not it was obvious to add cheese to the crust of a pizza. Okay, so the way that the patent process works is as follows. In this case, the original idea for the cheese crust pizza came out by a guy, an 18-year-old man I guess I would call him, in Brooklyn, was making pizza for his girlfriend, and he rolled the crust over so that it was hollow on the edges. And he realized that, hey, wouldn't it be great if we put some kind of a food filling in this crust? So you have the idea, and then you may have some sort of development of testing out different types of crust filling. Should it be cheese? Should it be meat? Should it be a typical pizza ingredient, or what? And once you've got that nailed down, then you go and talk to a patent agent or a patent attorney. Now, what I'm going to be talking about, a patent agent, this is what you could do if you pass the patent bar and work in this field. an inventor like this would come to you with their idea. The first thing you would do is ask them, well, have you done a patent search? Let's do a search, see what's out there. And at the time of this invention, these were the other similar patents out there. You can see the one on the left was kind of a bunch of pizza pockets, but it didn't have a crust, an outer crust filled crust. And then the one on the right is more of a donut-shaped pizza with a hollow center. So as you can see, it's different than those two, or it's novel, right? Our second requirement. So it's new enough that it looks like we could file a patent and argue that it's also not obvious. So we've done the patent search. Now we're going to file a patent application. Now, what does that look like? A patent application, if you recall from our U.S. Constitution, we have to teach others, teach the rest of the world how to make and use our invention so they can then look at it and improve upon it. So this is all of the pages of that patent application. You'll see that there are some drawings of the pizza, and then there's a description of how to make and use it. And then at the very end, we have what are called patent claims. And when we talk about someone having patent protection on something, what that really means is the language of the claims are essentially a law that no one in the United States can make, use, or sell that fits the description of these claims. And so it's very important that you are careful with your word choice when you draft these claims. So let's kind of visualize what it's like to draft these claims. There's these two other pizza inventions that are already out there. If you imagine this green circle as the boundary of a sentence that I'm trying to write, I'm trying to write this sentence as broad as possible without covering anything that's already out there or already been invented. That is what I'm trying to do when I write a patent claim. And so what you'll do is you'll stare at the ceiling and you'll look at your invention. You'll ask yourself, should I call it an individual food portion, or should I call it an enclosed stuffed portion? Should I call it a slice of pizza, a piece of pizza? And you're going to write your patent claims and file the patent application. So when you file a patent application, you still don't have a patent. You have what's called a patent pending, which means the application has been filed with the U.S. Patent Office, but they haven't reviewed it yet to either allow it or reject it. Now, we're entering here an engagement with a government entity, so it can be 2 to 3 to 5 years, depending on the technology, before you hear back from the Patent Office. So the inventor, when he originally started this process, was 18 years old. You might not hear, I don't think he heard back from the Patent Office until he was probably 21 years old or so. And that's when you get what's called a first office action, where they will either allow your patent claims or ask you to amend them. You'll do that, and you'll get a second office action where your patent gets allowed or finally rejected, and so on. So our inventor here, in this case, actually ended up getting a patent allowed. So what does that mean? He now has patent protection on his idea for 20 years from the date of filing. No one in the United States can make, use, or sell. Now, this is very important here. No one can make, use, or sell the claimed invention. So what we're going to look at, what are the patent claims? And this is where your life, if you're a patent professional, is reading these claims and figuring them out. So here we have the patent claim that was issued. And if you'll look at the title, it's a method of making a pizza comprising the steps of, and in step B, there's something that I've highlighted here, placing a plurality of separated individual food portions on the dough base. So you'll note that he does not have a continuous crust that's filled with a continuous piece of crust filling. It's a plurality, or more than one food portions on the dough base. And so when you hear about someone designing around a patent or improving upon a patent, what they can do is look at those words and say, well, I'm not infringing on that patent if I have only a single food portion, because this patent requires a plurality. And so, sure enough, his patent was issued in March 1995. Pizza Hut debuts the stuffed crust pizza with a continuous stuffed crust and increased their sales by $300 million in the first year. Now, as it turns out, our inventor had approached Pizza Hut with his idea, and they, depending on the source, they either turned him down or they offered him a small amount of money, like $50,000 is what I have seen, and he turned that down. He then turned around and sued them for, I think, $1 billion, which sounds outrageous and might be why he lost. So he lost his patent lawsuit. But when we think back to the purpose of the patent system is to provide a written description of an invention so that it encourages others to improve upon that written description. Pizza Hut really did just that. They looked at his invention and what was claimed, and they designed around it or they improved upon it, depending how you want to look at it. Now, our inventor, I don't know if he under-invented or if he just could not get claims that were that broad because of the other patents that were already out there. But nonetheless, he did end up starting his own cheese company that's I think a $20 million company that sources cheese to all the big box stores like Sam's Club and Walmart. So he still made his fortune selling cheese in one form or another, but not from his patented invention because the patent was too narrow. Okay, that's the patent process in general. And then here I just want to show another patent just for your own amusement, education, and looking at patent claims again. So this is a patent that was awarded to or assigned to Google, and it's essentially an app on a phone. So for example, if you're in another city, Chicago, and you want to eat pizza, you go on your phone and you type in a pizza place, and the different pizza places can bid based upon your customer profile on transportation options to you. And they can even bid on what percent of that transportation they are willing to pay for in order to drive you directly to their location. So it's kind of like that concept of the Internet of Things. Instead of typing in pizza place and getting a list of them, I type in pizza place and their car comes and picks me up and takes me to the real pizza place instead of the pizza place's website. But you can look at their claim and imagine trying to design around it and that sort of thing. But that is in another real world patent that's out there. Okay, so that's the patent process in general. I have a slide here, invention versus innovation. Another component of the Master of Science in Patent Law program that is tied closely with patents is the innovation capstone that we have. And it's kind of the question of how to think like Edison. I have some slides here that, let's see here. Yes, I have them. The innovation equation. So just to give you if you're an aspiring inventor or innovator, I don't have it on here on the slide here, but I can describe it to you. The innovation equation is actually a fraction. An innovation is measured by the benefit divided by the effort it takes to achieve that benefit. So for example, the light bulb is a great innovation because the effort of turning on the light is so simple that my 1-year-old can do it over and over again, turn the light on and off. And the benefit is amazing. You illuminate the entire room, you darken the entire room. You illuminate it, you darken it. So the benefit is huge, and the effort to achieve that benefit is minimal. That's the innovation equation. The other great example is the automobile. The benefit that you get from an automobile is traveling at 60 miles per hour or so, depending what the limit is. The effort you have to go through to achieve that benefit is minimal. It is simply changing the angle of your foot. So the innovation equation is maximum benefit for minimum effort. Every idea that you have, you evaluate it that way. And as part of the innovation capstone in the Master of Science in Patent Law program, we have as the goal of the program for you to prepare an invention and innovation that you can submit if you want Minnesota Cup and get funding for your invention. So that's kind of a component of the program, but it's also something that you can do if you're someone interested in patent law, because much of innovation is going to come from understanding the patents that are already out there. Okay, so now we've gone through kind of our background of patent law. Now what I can do is walk you through kind of a day in the life for these different areas of patent law. So it's very important to know that depending on your personality and your interests and the length of your career, there's not just one job out there for you to do if you're interested in this field. There are many different career paths just within the patent law field. So this first one is the one that we've talked about the most. It's right now the highest demand career path, and that's patent prosecution. That's once again where you're drafting the patent applications for the inventor. The guy invents the pizza crust, you draft the patent for him. So a day in the life, you might have a meeting with a different inventor. And what's cool about this job is you can have inventions from medical products to fishing lures to computer inventions and that sort of a thing. It just, I've had clients that are plumbers. It's just amazing the ideas and where they come from. And then you're spending your time drafting the patent applications, responding to the office actions where the patent applications is rejected or allowed, or filing foreign patents and that sort of a thing. So that's kind of the life. You're working on the front end of the invention process. That's the life of the patent prosecutor. And you can work in a law firm or you can work at a corporation and do this job. Next one is a day in the life of a patent portfolio manager. Now, this is typically a role that will be at a larger corporation. A lot of what you would be doing is patent research to find out if an idea is or is not patentable, and then making a recommendation. You'll be at a patent review board, so you'll have like a marketing person and a business person, a technology person, all at these meetings, reviewing each idea and deciding whether or not they should patent it. You can be involved in brainstorming sessions and patent strategy sessions. Now, keep in mind, as I mentioned before, I was a patent portfolio manager. This is a business role. And so when I would hold a patent board meeting, there would also be patent attorneys from the legal group at this meeting. They were worried about the legal aspects of the invention, such as who was the actual inventor, did we have a government contract that we have some duties to do with regards to patents, did we work with a partner, a third party outside of our company? And they would worry about the legal issues of that aspect. Whereas I, as portfolio manager, was only worried about the business interest. Does this idea have business value in terms of blocking a competitor or protecting a product that we're about to launch, that sort of a thing. So portfolio manager is at the same table with the patent attorney for completely different roles. Okay, next one is a day in the life of value extraction. So most universities, including the University of Minnesota, have what's called a tech transfer office. And what they do is they look to find licensing partners for the patents and innovations that come out of a university. So this is kind of more if you're the marketing type of a personality, you enjoy meeting people, going to the trade shows, shaking hands, that sort of a thing. You can look for licensing partners. Now, once again, this is a different role than what a lawyer would be involved in. Your role would be at the front end, finding the licensing partner. The patent lawyer would have a different role. They would be the one drafting the agreement and worrying about the language of the agreement, such as what if the company that you're licensing to gets bought out by a competitor? Or what if someone's infringing on the patent? Who's going to pay the legal fees to pursue the infringement? They're worried about those legal issues, but you're ahead of that part of it. You're worried about setting that deal up in the first place. So a day in the life value extraction. And then finally, a day in the life innovation. You're worried about what's possible. You're what's called the innovation champion. And essentially, if you think of innovation, everyone says that they're open to innovation. They love new ideas. But then when it all comes down to it, innovation is very disruptive to the direction that a company has been going for a long time or intends to go, that sort of thing. So really, an innovator is always thinking about what's possible and how to really make it happen. And it's a big challenge, and it's something that is always going to be on your mind if that's the role you're pursuing. Patents are kind of the currency of innovation, is that you can say, for these efforts, we have a patent. There's a lot that we can do with it in order to leverage our efforts and get investments and that sort of thing. So those are the kind of different roles, and then here's our curriculum for the Master of Science in Patent Law to prepare you for these different roles. Once again, the Master of Science in Patent Law program is a one-year master's degree. So in 1 year, you're going to learn all of these different areas of patent law. The fall semester, we have a patent law course, patent prosecution course, portfolio management course. We have a Patent Pro seminar where we have speakers from industry coming in every week and talking to you about the different areas of patent law. then we have a writing, analysis, and persuasion course, because the number one most requested feature from employers are people with strong writing skills, because strong writing skills mean strong communication skills. So that's a course that's been added specifically for this program. Spring semester, you go more into depth into these different areas of law. And then we also have the Innovation Capstone program, where you will actually come up with your own idea. And if you want, you can submit it into the Minnesota Cup to try to get venture capital funding. We have a Patent Law Pro seminar that semester also, and an ethics for patent agents, because you're in this gray area between a lawyer and a non-lawyer. We want you to make sure that you're not doing anything that can put you at risk of a liability. There are a number of electives. There's listed on here that you can choose from also. There's international patent law, patent research, litigation, copyrights, trademarks, mergers and acquisitions, and so on. Additionally, we do allow people to take technical electives if they so desire to do that. And then finally, a huge bonus of the program is, in order to become a patent agent, I mentioned before, you have to pass the patent bar. So we include a patent bar review course, which is a 5-day course that prepares you for passing the patent bar exam. It's actually a fairly difficult exam. It has about a 60% pass rate, the last that I had checked. And so the patent bar review course significantly improves your chances of passing that exam. Okay, so that's a summary of our program. Patent bar exam. Let's kind of rush through this. It prepares you to be a patent agent, and once again, it's a 1-day, 100 multiple choice exam that you have to get, I think, 75% right on in order to pass. And it's all about practical matters of drafting patent applications and filing them with the United States Patent and Trademark Office. So it's a very fact-driven exam. It's not an intelligence exam that you can go into without studying. It's something that's just, how many days do I have to respond to this office action? Things like that. Okay. How to apply the program. We need a statement of interest, and we're really looking for your quality of writing in this, and I think I weigh that pretty heavily. Letters of reference, anyone that can attest to your ability to succeed in the program, transcripts, and a resume, and GRE and LSAT scores are optional. So now, who is this program usually attractive to? The number one thing that I hear, we currently have 7 students in our program this year, and I think all of them basically said something along the lines of that they love science and engineering, but they don't want to work in a lab. And this gives them a great opportunity to still be in that field, but be doing a lot of interesting things and get to work across a wide range of industries and technologies and still use their science and engineering background. Another attractive thing about this program is it's a master's degree that you will get in 1 year, and as opposed to going to law school for 3 years and wondering whether or not that's the right decision for you. Once again, and most finally, I think that the great part of this program is patent law is a field that is in high demand right now, and more specifically, there's a high demand for people without a law degree that have the science and technology background to work in this field. So that's really all I have for the presentation. If you have any questions, feel free to send them in to patlaw@umn.edu. We are accepting applications on a rolling basis. Probably sometime in December here, we will review our first group of applications, and we'll accept them probably through the early spring of next year. So once again, my name is Chris Frank. I'm the program director of the Master of Science in Patent Law. Thank you for attending this session, and feel free to send in any questions. Thank you.